Hello, welcome back to BiteSize Law. This is the third of 4 videos on interests which override under the Land Registration Act 2002, Schedule 3, Paragraph 2. Here's a quick reminder of what I covered in the first 2 videos. So we looked at the circumstances under which a third party, so that's someone who isn't a legal owner of land, can have an interest which overrides under Paragraph 2 of Schedule 3. So now I'm going to look at common errors students make. I'm also going to share with you some practical advice on how you can make life a bit easier for yourself in the exam to enable you to produce your best answer. I taught land law on undergraduate and postgraduate courses for over 15 years, and I've also been an external examiner. So I have written many exam questions and acted as a moderator. I've marked thousands of students' answers, so I have lots of relevant experience. So here's the first problem, and it's poor structure. Now, if you adopt the IRAC method, then your answer should follow a clear and logical structure. And I would encourage you to use this method for all problem-based law questions. But there are a couple of errors that students make which are specific to Schedule 3, Paragraph 2. So in terms of structure, I'm just going to introduce them to you now. And the first one is dealing with either of the exceptions before you've looked at the general rule. And the second one, which is linked to the first, is conflating the requirement of actual occupation under the general rule with occupation not being obvious under the exception in paragraph 2c. So here's the first one again, and this is just to remind you that you should always follow the pattern of the statute. So decide if the third party has an interest and was in occupation at the time of the disposition first. Because if you start to look at either of the exceptions before you've done this, your answer will be muddled and you're more likely to make a mistake. And the second one is linked to the first, which is that students quite often conflate the requirement for actual occupation in the general rule with the exception in paragraph 2c. And I think that there are 2 reasons for this. The first one is that the word occupation appears twice in the statute. So students try to save time by dealing with the 2 points together. It is much better to deal with them separately in the order in which they appear in the statute. And the second reason that students do this is that you'll very often be using all or the same facts at 2 different stages in your answer. So again, there's a temptation to deal with the 2 different issues together, but my advice is don't. The second mistake students can make is when looking at the exception in paragraph C, which, if you remember, states that the third party's occupation wasn't obvious on a reasonably careful inspection of the land. So in the Boris and Teresa scenario, we used the fact that there were female belongings at the property and the seller was a sole male legal owner. And the mistake students sometimes make is they say it was obvious that there was someone living there. But remember, what you're looking for is occupation by a third party. Now, the third error, it's not particularly common, but it is so serious that it's worth a mention. So I have seen answers where students have tried to argue that paragraph 2 applies where the third party isn't actually occupying the land over which they have the interest. So to illustrate this, imagine that Jeremy's neighbour had an equitable easement. So for example, the neighbour has a right of way for life over the back garden of Yellow Door. But the third party right that the neighbour has doesn't mean that the neighbour is occupying Yellow Door. So the neighbour can never have an interest under the easement which overrides under Schedule 3, Paragraph 2. And the same is true of the benefit of a restrictive covenant. Now, the fourth problem is careless or incorrect use of terminology, and I've got a few points to make here, some of which are serious, some of which are less serious. So the first one is a very serious error. So the phrases doctrine of notice, land charge, constructive notice and Land Charges Act all relate to situations where title is unregistered. So if you use any of those phrases in an answer to a question where title to the land is registered, it suggests to the examiner that you don't understand the difference between registered and unregistered title, which is a really serious problem. Now this one isn't particularly serious and it won't have a devastating effect on your grade, but it does help to make your work appear more accurate. So remember to reference the statute correctly. You're referring to a schedule, not a section, and it's broken down into paragraphs, not subsections. And again on this slide, these are not very serious errors, but try and get them correct if you can, because it just makes your answer appear more polished. So it's very common to refer to registered land, but actually, strictly speaking, the correct way to refer to it is registered title, because it's the title to the land that's registered, not the land itself. If you're dealing with the Land Registration Act 2002, then strictly speaking, you should refer to interests which override rather than overriding interests. Now, it is a minor point, and it's very easy to use the phrase overriding interests, but particularly if you're dealing with a coursework where you've got time to check these things, then try and refer to interests which override. Now, in the next one, this is a really common problem and it can have quite a serious impact on the quality of your answer. If the facts are clear and unambiguous, do not advise on hypothetical situations. I'm going to suggest to you later that you do a brief answer plan, such as the one I'm going to take you through in the 4th video. And one of the reasons for doing this is to help you to identify the relevant issues. Sometimes students will include irrelevant materials by mistake, but sometimes they know it's irrelevant and include it anyway. They've learnt the material, they understand it, and they just want to tell you about it. And they do so in the hope that it's going to get them extra credit. But if it's not relevant, then the examiner can't give you credit for it. And if you include irrelevant material, you'll have less time, or if it's a coursework with a word limit, less words to deal with the more relevant issues in sufficient detail. So one way in which you can avoid including irrelevant material is to imagine that you're advising the client who's sitting in front of you. They don't want to hear about hypothetical situations, what they could have done, what they should have done. What you need to do is advise them on what has happened. A client who's paying for your advice doesn't want to pay for advice that doesn't relate to their particular situation. So the best advice that I can give you is this. A good answer is not only about what you choose to include, it's also about what you choose to leave out. And finally, what I'm going to go through now are some practical tips to make life easier for yourself in the assessment if it's an exam. Many law schools allow students to take their own copy of a property law statute book into the exam with them. And if you can, I would strongly recommend that you do this. I'd also recommend that you acquire a copy as soon as possible so that you get used to using it. Don't just leave it unopened on your desk, open it at the relevant page during classes. And something that students don't really appreciate is that it is absolutely not the same as looking at a statutory provision on a computer screen. So if you open up the statute book for the first time in the exam, you're just adding extra pressure on yourself. And finally, please do check your course rules very carefully to see if there are any restrictions on what you can do in any book that you take into an exam. Okay, so let's look at how you're going to deal with facts in an exam. And I'm assuming that this is an unseen exam paper. So when you first open the exam paper, you'll read all the questions and decide which questions you're going to answer if you have a choice. And when you've decided, read the facts again very, very carefully. And it's a good idea to take a highlighter pen into the exam with you and use it to highlight the key facts. But don't do this on your first read through of the facts. Always make sure you wait until your second read through of the facts when you're ready to answer that particular question. I mentioned earlier how important it is to plan your answer in an exam. So make a list of all the key points that you need to include and tick them off as you deal with them. And I find it's a good idea just to quickly jot down the names of the parties in the margin so that you don't get them muddled up. And when you do a plan, always make sure that you finish it before you start answering the question properly. So work through your answer right through to the end. If you can't complete your answer because you get stuck halfway through, then it'd be much better to choose a different question if you have the time and if you have a choice. The most common reason why students either fail an assessment or get a grade that does not reflect their true level of ability is that they don't answer the correct number of questions in an exam. So you must always attempt the correct number of questions, even if your final question is, a pretty poor answer, but you should attempt it nevertheless. So think of trying to obtain marks like trying to squeeze water out of a sponge. So when you first start to squeeze, water comes out very easily. But as you continue, it gets harder and harder to get water out. And obtaining marks in an assessment works in the same way. It's easier to get marks in the first part of your answer, just dealing with the basics, than it is to get marks later on in your answer when you're dealing with more sophisticated issues. And just to prove it to you, I put an example on the slide there. So imagine that in this exam, the student is required to answer 3 questions. Now in the first example, they've only answered 2 questions and they've done very well. They've got 72, which is usually a first class mark, and 68, which is a high upper second mark. But when the final grade is computed, the total of those 2 answers will be divided by 3, which means that the final grade will be 46%, which is usually a mid-third. But look what happens if the student answers 3 questions, and okay, the final question isn't great, it just scrapes a pass, but look how it has an impact on the overall grade. The student still gets 60% overall, even though their final answer wasn't as good as the first 2. And linked to what I've just been saying is that you have to get your timing right in an exam. So before you go in, find out how long it is, how many questions you have to answer, and is there a particular waiting for questions, and then work out how much time you need to spend on each question. Because what you don't want to do is to have to do that calculation in the exam when you're under pressure. When you're answering each question, only spend the correct amount of time answering that particular question. If you run out of time for that question, leave a gap. You can always go back to it later if you have time. And students often use bullet points in exams, which will get you some credit, but not very much credit at all. And I'm sure that students believe that it will get them more credit than it actually does. So only use bullet points in an extreme emergency, in the last dying minutes of the exam. So thank you for watching. Please subscribe to my channel if you find it helpful, or like and share, as it really does make a difference. In the final video in this series, I will be going through my complete answer plan to the question involving Boris and Teresa. So I won't just be concentrating on Schedule 3, Paragraph 2. I'm going to answer the question from the beginning to the end so that you can see where Schedule 3, Paragraph 2 slots into an answer on third-party rights in relation to registered title.